Okay, if we can call this to order, I'd like to call to order the regularly scheduled Planning Commission meeting for the City of Placerville, August 20th, 2013. And I'd like to begin with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And if we can have a roll call, please.
Chair Briggs.
Here.
Vice Chair Russell.
Here.
Member Lowry.
Here.
Member Drobish.
Here.
Member Friend.
Thank you. We'll move on to item 3, which is the consent calendar. All items listed under the consent calendar are considered routine and will be enacted by general consent unless any commissioner requests a roll call vote or unless any member of the commissioner's staff wishes to remove an item for discussion. The reading of the full text of all resolutions will be waived unless a commission member requests otherwise. Do I have a motion to adopt the consent calendar?
So moved.
And a second?
Second.
All in favor?
Aye.
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 Okay, consent calendar is adopted. Item 4, which is items removed from the consent calendar, that's none. Item 5, which is items of interest to the public. This portion of the meeting is reserved for persons wishing to address the commission on any matter not on the agenda that is within the subject matter jurisdiction of the Planning Commission. State law prohibits the commission from acting on items not listed on the agenda except by special action of the Planning Commission under specified circumstances. The chair reserves the right to limit the speaker's time to 3 minutes. The chair will recognize the speaker and ask that they state their name for the record. Personal attacks on individuals or comments which are slanderous or which may invade an individual's personal privacy will not be tolerated. Do we have any items of interest to the public? Seeing none, we'll close that item and move on to item 6, which is communications. Do we have any communications?
We have none from staff.
Okay, great. We'll move on to item 7, which is new business. I have to recuse myself from this item because it's part of the property is owned by my grandfather and also my client. Turn it over to Commissioner Russell.
Who has the staff report on this one?
Thank you, Vice Chair Russell. Pierre Rivas, Development Services. I'll give the staff report on this. This is a finding of general plan consistency. It's a request that was made by the County of El Dorado that the Placerville Planning Commission make a finding pursuant to State Government Code 65402B that the proposed future development of a court facility upon property within the city limits is in conformity with the city's general plan. The project site is generally located adjacent to the existing El Dorado County Jail at 300 Forney Road, and that's assessor's parcel numbers involved are 325-300-02 and -32. This action is exempt from the Environmental Quality Act pursuant to 15060C3 of the California Environmental Quality Act, and that this is not a project under the meaning of the law. To give you a little background, Government Code 65402 basically states that a county shall not acquire or dispose of any real property in any city if such city has an adopted general plan, which the city of Placerville does, until the location, purpose, and extent of such acquisition or disposition has been submitted to and reported upon the planning agency as to the conformity with said adopted general plan. The county did make a formal request by letter dated July the 23rd of 2013, and that's contained as Exhibit E in your staff report. And it describes, with that, it describes the transaction for the county's, or actually it would be the state, the future Placerville courthouse. Just in brief, and you can refer to Exhibit C in your staff report. Exhibit C will show you the boundaries of the two properties that are involved. Basically a property that's owned by the County of El Dorado, and that's the property that currently houses the existing jail facility, and then another piece of property is owned by the Briggs Family Trust. And what's being proposed is the county will, in trade, give the Briggs Family Trust approximately 5.2 acres of property. It's undeveloped. And then in exchange, then the county would acquire 5.2 acres from the Briggs Family Trust, and then combine that with approximately 2.5 acres of the site that contains the jail, and then eventually that will be then disposed of and provided to the state of California for the future courthouse. If you look at the general plan exhibit, the property that would be provided to the Briggs Family Trust is zoned public facilities. There is no proposal to develop that property at this time by the Briggs Family Trust. At such time, then they could submit an application to develop the property, which probably would include a general plan amendment to change it from public facilities to some other suitable land use designation. Probably would be commercial. The adjoining, the property that the county would be acquiring has a general plan land use designation of commercial. And just in brief then, it is staff's opinion that these land transactions are consistent with the city's general plan. We've outlined the analysis in your staff report, and staff is recommending that the Planning Commission find the proposed land transaction between the County of El Dorado and the Briggs Family Trust, and between the County of El Dorado and the State Administrative Office for Development of the new Placerville Courthouse facility is consistent with the applicable policies of the adopted City of Placerville General Plan in accordance with Government Code Section 65402. And just for your information, because this is it's a more obscure section of the government code, I did provide you a copy of that section of the code. The city is required to report back to the applicant, this case, the County of El Dorado, within 40 days. If we fail to do so, then the finding of consistency will be deemed automatically in full compliance with the general plan. And that concludes staff's report. I'll be happy to answer any questions that you have at this time. We do have Kelly Webb from the County of El Dorado, and she's here representing them, and she could probably answer any other questions you have as well. Thank you very much.
Thank you. Any questions of staff?
One I had was hearing that this is just a formality, a yes or no vote has no bearing. Is that true?
You know, it's difficult to answer that. I attempted to do a legislative search and determine the history of why the state legislature at some time passed this, because it doesn't apply to the state itself. It just applies to counties and cities. So whenever there are these transfers of property, be it undeveloped property or be it a building, this 65402 finding is required prior to, you know, a county or a city acquiring the property. So it's still pretty early in the process, and so this would be the first step then, at least one of the hurdles that the county would have to pursue. But once they have this, or the 40 days passes, then they can move forward with the property transaction.
Good. Okay. If that's all the questions we have, well, I guess we can open the public hearing on this matter. Is there anybody that wishes to speak to the project? Would any of the commission have a question? I understand there's a rep from the county. Would any questions for that person?
I'll ask one.
Thank you.
How far along is the CEQA process for this project? What stage is it at?
Well, the project, the CEQA process is underway. However, we have been stalled for several months pending state budget issues. So we had started the process last fall. It came to a halt, and we just, in the last 3 months or so, have really started discussions with the state again. So they are in the process of regrouping and pulling all their information together. I didn't bring with me their current schedule, otherwise I could tell you, but They are working on that, and we're hoping to get a meeting together with them very shortly to determine what the actual dates are going to be to roll out that whole process. And I believe that we could probably have them come and talk with you at some point if that's what you'd like.
Are you aware of any plans whatsoever for the Main Street Courthouse?
At this point, no. It was part of our discussions early on and how we would handle that. At this point, we have the Building C property that the state currently owns, which is a joint, it's a county building that, because of some state legislation, the county had to provide space in that building to the state that the courts already occupied. So one of our objectives with this project is to exchange the land for space in Building C, and then the courthouse on Main Street is also a part of that consideration. But because we've had such a delay in our process, we really need to go back and revisit the values on the buildings and see where we're at in terms of a exchange.
So who actually controls Main Street Courthouse building and property?
There is a transfer of responsibility in place that because of a seismic issue, the county was not able to fully transfer that building over to the state. However, they are responsible for the maintenance and control, any repairs and things like that that actually occur with that building. So it's kind of a shared responsibility in a sense, but for the most part, they are responsible for the majority of the upkeep at this point.
Thank you.
Vice Chair Russell, if staff could just add a few comments to the question. There was a notice of preparation of environmental impact report and an initial study that was prepared for the Administrative Office of the Courts. And this document is dated April of 2012, and the comments on that ended in May 22nd of 2012. So at least that's the last actual document that was circulated for public review and comment. They will be preparing an EIR, but we have yet to see an administrative draft. But we can certainly contact them and try and get a schedule and report back to you at your next meeting if you would like.
I'm curious about the seismic issue. Now, do I understand that seismic retrofits were not able to be completed because of budgetary constraints or engineering impossibility? Or
Well, the state really did the seismic evaluation on that building a number of years ago. And through the process of transferring the building, that was brought up as an issue. The state was prohibited from taking control of that building based on some other legislation that exists. I think it's SB 10 or something like that. So it was just written into the agreement that the county would have to maintain it for seismic uncertainty, if you will, for a period of 25 years. But other than that, the state has maintained maintenance and control of the building. So it's really just a formality that was kind of one of those obscure things like Pierre was referencing that came out through the legislation.
thanks.
Yeah, Vice Chair, if I may, staff would just point out that the topic in regards to the existing main courthouse on Main Street is not germane to this particular item. It's not on the agenda.
I understand that. We're still all very interested, though, in the future
Yeah.
of that building. Any other questions? Thank you.
Thank you.
Anybody else of the public wishes to speak on this matter? Hearing none, we'll close the public hearing and bring it back to the commission for our action. If there's no other discussion, perhaps someone would like to move that we move this forward?
I'd be happy to make the motion, but I'm still not quite fully skilled on all the verbiage required to make an official motion. So I guess my motion is that we accept the findings of staff and proceed with approval of this item.
That's fine.
Thank you.
Second.
Okay, we have a motion and a second. I'll call for the vote.
Member Lowry,
Aye.
Member Drobish,
No.
Vice Chair Russell.
Aye.
Point of order. Who made the motion? Who made the second? Thank you.
Okay. With that, I believe we can bring our chairman back.
Okay, we'll move on to item 8, which is a workshop. This is zoning text amendments, front yard regulations, and I believe Mr. Painter has this staff report.
Yes, I do. This a similar workshop, as outlined in the staff report, was conducted a couple of years ago, and members Briggs and Russell probably remember that. What it involves is the city's received complaints over many years regarding the parking of vehicles in front yards, the heights of fences in front yards, creating kind of a fortress type effect. And our code currently doesn't address those issues very clearly and concisely. And recently, members of City Council have asked staff to bring this forward to them in the near future. And staff has provided for you some, just for items of discussion, to open discussion. The changes to city code would affect a specific section of the zoning ordinance related to what's called yards, otherwise known as, or AKA, setbacks. Currently, the code restricts building setbacks, but it does not appear to address the parking of vehicles in front yards or fences and things of that nature. With the exception of fences at the intersection of two streets, where we do limit the fence height for 3 feet to allow for sight distance. On a page, well, to give you some examples of what we're looking at here in terms of violations or potential violations and issues related to the city wanting to regulate these things are provided for you in Exhibit A. And there are some photos, only one of which is within the city limits of Placerville. The others are more to be characteristic of the types of things that we are receiving and the complaints that we receive, usually on a monthly basis of some sort. So on page 4 of the staff report involves really the meats and potatoes of our changes to city code that, again, we're bringing forward for discussion tonight. Staff, we're not requesting that you formally make a decision. It's just to provide staff and for the public to provide feedback and to discuss this issue. And city staff will kind of take all this in and report back to you in the very near future related to these issues. So on page 4 of staff's report, or my report, on the underlined text shows the amended language. And for those in the audience that don't have the benefit of staff's report, if it would help the chair as well as the members of the commission, I'll be happy to read those into the record.
If the rest of the commission wants that to occur, I'm I'm fine with it. I've
Again, the
got-
public does not have copies of this text.
Well, then go ahead.
Yeah, under section 10.4.3, subsection C of City Code, where it addresses fences, walls, and hedges, staff is requesting, again, to discuss adding language related to front yards and adding number 2, quote, front yards may have the following encroachments. A, solid fences, walls, or hedges not exceeding 3 feet in height. B, fences that are 50% open or more, not exceeding 6 feet in height. C, other structures not exceeding 30 inches in height. D, parking or storage of vehicles except within a paved or graveled driveway. Recreational vehicles, boats, utility trailers, equipment, and similar items shall not be permitted within the front yard. Number 3, fences, walls, or hedges which exceed the requirements of this subsection shall be subject to a variance procedure that's set forth in 2 other sections within City Code. And when staff looked at this section of code and with the addition of adding recreational vehicles into the mix, we noticed that our code does not define that term. And staff is also, again, for discussion tonight to provide you a definition of that term, which would, if added, would be added to section 10.1.4 of the zoning ordinance, which is our definition section. And that would read, recreational vehicle, a vehicle type unit primarily designed as temporary living quarters for recreational or travel use, and which either has its own motive power or is mounted on or drawn by another vehicle. Examples of recreational vehicle or recreation vehicles are travel trailer, camping trailer, truck camper, and mobile and motorhome. Recreation vehicle does not include mobile homes. That last sentence was added just to ensure that there's another section of City Code relating to mobile homes where that term is defined. So to set forth the discussion tonight, once again, staff is not requesting that you make a decision on these items tonight. It is strictly for discussion. We are hoping to hear from each of you, as well as members of the public who are interested in speaking on this action or item. And that concludes my report.
Thank you, Mr. Painter. Do we have questions from the commission for staff? Mr. Drobish?
I noticed at the beginning of the staff report, it says to, so workshop and to receive public input. So how was this advertised for the public to know?
Our general public notice related to notifying on our city's website, Facebook, and our posting on the wall at City Hall, as well as this building, a minimum of 72 hours prior to the meeting.
Other questions?
Yeah, I'm curious about 2D. Are driveways, I presume paved driveways are paved by permit. How about gravel driveways? I'm concerned about the temptation to game the system by putting, somebody hauling in loads of 3/4 crush and put it under their yard cars and call it a day.
It's very, very astute observance. I know Director Rivas and I have kind of discussed this issue in a little bit more detail after this item or packet had gone out to you. And the discussion talked about perhaps defining what is a driveway. And we have not come up with a conclusive definition of that, but I understand your concern. There might be a workaround to any type of regulation we put forward without really defining what that driveway is. But yes, to answer your question, driveways are typically surfaced of some sort, whether they be asphalt or concrete. And yes, they do require permits. Encroachments to the city streets are required as well. And again, these provisions would relate to residential uses. there are other specific sections of city code addressing driveways and accesses to commercial type uses. So if we'd be happy to hear any input you have regarding definitions of driveways, that would certainly be helpful, although it's not really couched in the staff report tonight, but I think it's open for discussion, absolutely.
Commissioner Truitt?
So does that mean that there is no actual width of a driveway? It could be the entire property?
The city has, and perhaps Director Rivas can maybe correct me, but we have engineered standards, and I don't have copies of those in front of me today, but my recollection is that they have a minimum width of 10 feet and a maximum width of 20. Now, we could incorporate that type of language into a definition if that's something we bring forward back to you, or if you recommend that. So that might be something that certainly goes, well, it's relative, absolutely. Typically, well, I live in a home, just for point of clarity, in a home that was built in the 30s, and I don't own the home, but there's a single car driveway, and I would almost guess that it has probably a 10-foot encroachment, and there are certainly other houses within Placerville that have the same issue. They were built at a time when automobiles were Model Ts and or something of that likeness, and those, of course, were very narrow in width and didn't have much length to them, and over time, of course, cars got bigger and standards seemed to evolve to more of the standard, which is 20 feet in width today, which is what you'd find in most subdivisions that were built, I'd say, in the last 20, 30 years.
I have another question. I have somebody that wanted me to ask if front yard gardens are allowed due to expensive water and such, and some cities actually ban that process. And so since this is dealing with restrictions on your front yard, I was just wondering if front yard gardens are restricted.
Gardens per se are not. However, there could be a garden in the broad sense of the term. When I think of an English garden specifically, they may have hedgerows which are 6, 8, 10, 12 feet in height. That may come into conflict with our existing language and language proposed today. If you're thinking more of a vegetable garden where there may have tomatoes that reach 6 feet in height, or corn stalks, things of that nature, which are more temporary and you can see through them probably more than 50%, we probably wouldn't have an issue with it conflicting with the language here. Pierre, would you care to maybe add anything more?
Sure. The only thing I would add is no, there's nothing here really looking at preventing the type of landscaping, whether it be a lawn, a vegetable garden, some other kind of planting that the property owner wishes to place within that 20-foot front yard setback. But I think what Mr. Painter was getting to is the city right now lacks any regulation with regards to fencing, and that's very atypical. If you even look at El Dorado County or any of the surrounding cities and other counties, they regulate, typically looking at a solid fence can be up to 30 inches within the front yard setback at the property line. And it could actually, in most places, you can go up to 6 feet as long as it's 50% open. And so, again, it's trying to stay away from the situation where you have a fortress effect where you're going down a particular road. Say, for example, Cumbelic. Now, Cumbelic, you're looking at side or backyards, and so that was a special exception. It's not a front yard because the front yard is actually within the subdivision itself. But we wouldn't want to have a situation created where all of a sudden everybody is putting up these high, 6 foot or higher fences within the front yard setback or essentially up to the property line, so that you really change the whole look of the community. I mean, that's the intent. And a lot of the complaints, and again, we're just talking about the 20 to 30 foot swath would be constituted the open space. Once you're 20 feet off the property line, then they can have a solid 6-foot fence if the property owner wishes. And that's typical. You see that in a lot of subdivisions. You know, a privacy area for a courtyard or something like that. But staff was receiving complaints about contractors' storage yards, storage of material, those kinds of things within a front yard in a residential area can have a blighting effect. And so I think that's what this is just looking at doing, is just sort of providing that additional regulation to ensure that a front yard is just that. It's being maintained as a required yard and not for other kinds of uses that would belong elsewhere on the property.
To add a little bit to that, unless there's a question. Thinking about, again, a driveway and what have you, there could be situations, circumstances where the lot and the house that was built and the desire of the property owner to have perhaps a wider than 20-foot driveway. I think from what's at least my initial draft of how the language may read regarding a driveway, I think we would restrict it probably to 10 or 20 feet until the setback line, and then after the setback line, someone could have a wider apron if they wish to display whatever they wish to on their property, and that would allow, again, for that first 20, 30 feet, depending on the setback of the zone, to accommodate really a yard. Be it shrubs, be it lawn area, what have you, and not the parking of vehicles and trailers and fences that exceed a certain height.
Other questions for staff? I have one. Let's say that right now I'm in the city limits and I have a recreational vehicle parked in my driveway, and then this language is changed. What's going to happen to me?
The city would initiate a enforcement action.
It wouldn't be considered a pre-existing non-conforming use?
I don't think we would specify the parking of vehicle, something that could be moved
Right.
to accommodate the setback would be different than perhaps without particular naming a particular property, but there are one property that I walk by daily to come to work is a property on Coloma that has cypress trees that are probably 25 or 30 feet in the air, and they run parallel to their property boundary with the back of the sidewalk. Under the code section language we're potentially adding, those trees would violate the code. In that particular context, those exist, and the city would not be approaching them to change that. Does that?
Yeah, that makes sense. Any other questions?
Perhaps language should be included in there to make that clarified, so 10 years from now, 20 years from now, somebody doesn't read this and say, oh, now you got to take your ancient camellias down to 3 feet.
Okay.
I believe the code has a legal non-conforming or conforming use section of the code that addresses that.
Okay.
You know,
Great.
in the entire code.
I'd like to open it up to the public. We have any members of the public that'd like to go ahead and step up to the podium if you'd like.
My name is Rick Hudak. I had a question. You had photos there showing sort of bad examples of things you don't want to happen. Is that correct? You guys
think
all
it's a-
have these photos?
Yeah, I
No?
think that's an
They're on
open-
the Facebook page?
Yeah, I think it's an open forum. I mean, it's a workshop.
But these are photos that this gentleman just said weren't even taken within the city limits.
I didn't hear that actually said by staff.
Yeah, three of the photos were, I think we just found off the web, and then one of the photos is taken, it's actually on Coloma Street. But they're just meant to illustrate something that was like some of the complaints that the city's received.
Well, it sounds like you've got complaints, but then you've got photos that don't even show those complaints. The photos are outside of the city. That just seems silly, that your examples don't even exist in the city.
Well, I don't think it's meant to be silly, it's just meant to be illustrative.
But you've got complaints, so why don't you take photos of those places? So
We
that
have
what
a-
we're looking at on Facebook is real, not sort of
To address the
Out there.
question,
Yeah, go ahead.
if we do bring back this back forward, we will certainly provide you with examples within the city limits, if that's the purview of the
And if I
planning
recall, last time you did that, and the gentleman whose property you photographed was quite irritated.
That's correct.
Well, if this passes, he's probably going to get more irritated, huh?
Well, I
Thank
think
you.
what staff was trying to do here, Mr. Chairman, if I may, is, we don't want to cloud the issue with precise examples, especially if the city is pursuing enforcement.
Sure.
Or if there's some complaint. We really, we can do that. We can take some pictures of examples, but, right, we don't want to anger residents out there. We'd like to keep it on a more general situation as far as how can we best regulate use of the front yard setback, looking at what its intent and what it's intended to do, and not get into, very specific, parcel-specific issues.
Makes sense. Is there anyone else from the public that'd like to address this? Okay. Commissioner Russell?
Just a couple comments. The last gentleman that spoke, there's been complaints and comments about these things, but there isn't an ordinance yet to address those. So to identify those specific items really wouldn't have any purpose at this point. If an ordinance is ever adopted, then we'll be looking at specific, I think, instances that violate that. I just wanted to make one comment about item C on your list of things. It says other structures not exceeding 30 inches. That could be a real can of worms. So you'd better, if we ever implement this or write an ordinance, it's going to have to be an exhaustive list of structures that qualify for that. It could be a boulder that someone puts in their yard for landscaping. It could be a landscape mound. It could be a bird bath. I mean, you could just, this arbitrarily saying anything over 30 inches would cause a problem. That could really be a can of worms.
I had that same note, actually, is how do you define structures? And I don't have a good definition, but I had the exact same note. The other note I had was on B 10-1-4, I would just insert a cross-reference to the zoning ordinance's definition for mobile home, so that way there's no question about that. And I do agree with the earlier discussion about potentially defining what a driveway is, and it may be the best choice to just use the existing minimum maximum sizes for that. And that's all I have. Anybody else? Commissioner Trowbridge?
How many complaints did the city receive last year, and how many over the last 10 years? Are you seeing an escalation? Can you quantify it?
I don't have that tabulation in front of me, but recollection would be an average of 3 to 4 per year.
And do you know or have a feel that it could be just 1 or 2 people having a feud and the majority of the complaints come from just a couple people?
I don't know if I can answer that, because from 3 to 4 years ago, I couldn't tell you who made those complaints. They could be just at the counter. Our policy now is that we require a formal complaint written, provided to us, so we can follow up. In this case, since it really isn't an action that violates code, we haven't been enforcing.
So we're looking to regulate everyone for 3 or 4 complaints a year.
I think if I can try and answer that, I think what staff is trying to do is look at an area in our code which is an area that's unregulated, and that's the front yard. And staff feels the front yard setback serves a purpose. It is very important for the maintenance of a neighborhood, the look of a neighborhood, depending upon the kind of uses that goes on within that area, as opposed to the backyard, then could have a positive, but it could also have a very negative effect. So that's why we're having this workshop for you. It's not really based on the number of complaints or whatever, but like I say, the City of Placerville's code in regards to fences and structures in a front yard setback is very atypical. You look at any other city or county, you can't have structures, and that's not a rock, that's a building or some structure that requires a building permit. And most ordinances do define what a structure is. I don't have that readily available, but I would gamble that our code does define what a structure is.
It does. It's anything built or placed upon the ground.
Is there any part of someone's private residential property that you feel the government does not have to regulate?
I don't understand the question.
How much regulation does the government need? You want to control what people do with their own private property. And the vehicles, their own private vehicles, they can park on their own private property.
Well, I think the staff's kind of answered that question. I think they've told us why they've brought this before us, and you know, whether the city adopts the ordinance or not, it's going to come back before us again with changes. At that time, it may be, I think it'd be useful for Commissioner Drobus, and I wouldn't mind seeing myself, you know, some type of data regarding the complaints. And then even, no matter what we do, it's just a recommendation for city council. So ultimately, they get to decide, you know, how much government regulation we have.
Are you going to, even though it's just a workshop, are you going to take a poll on what we like and don't like after discussion? Or should we say it?
Yeah, just go ahead and say it.
I would like to see number 2, section D, absolutely stricken and thrown away.
Okay. I don't have major issues with it. I haven't heard from the public or the other commissioners that there are major issues with it. So I'd recommend that staff, you know, make the changes that we've talked about, you know, clarify some of these issues, bring it back to us as a formal action item, and then we'll take more input from commissioners and the public at that time and make whatever recommendation we do to city council. Any more discussion on it? Okay, let's close the item. We'll move on to.
I do have a
Oh, you
comment.
do? I'm sorry. I thought you were nodding as in we can move on. Go ahead, Commissioner.
So within the limits I have in parsing this kind of thing out, I'm going to settle on 2 pieces to this. For me, one part of this is the yard car remedy. There are plenty of places in California like Lakeport and Clear Lake where you can indeed have your yard in your front yard, and everyone's free to seek those kinds of neighborhoods out. The other one, what I've heard the fence rules called in general were called spiked fence rules. And spiked fence rules probably exist at a guess 85–90% of the incorporated towns in California. That's what we call them in Southern California. And again, I think if your aim is to have a harmonious neighborhood, there are certain limitations. A specific example I can think of in my mind is at the house at the other end of the block. The people bought the house for $250,000 and have probably put another $200,000 into upgrading. It's a 1930s vintage house. They might have a view on things if their neighbors across the street had 3 station wagons and a Class C motor coach in the front yard. So I see it from possibly a different point of view.
Well, it sounds like we're going to have an ongoing, you know, in-depth discussion on this when it comes back. So I think we all appreciate staff's work on it, and if I would recommend to the commissioners or any of the members of the public, if you have more input that you'd like to provide to staff prior to it coming back, which I'm sure it'll be a little while at least, I would commend you to contact City Hall. Let's move on to item 9, which is matters from commissioners and staff. Do we have any matters from commissioners or staff? Mr. Painter?
Yes, staff is very pleased to announce that the city has been designated a Preserve America community. You may remember, perhaps if you follow council and their agenda, and the Mountain Democrat did a quick piece on it as well. The Historical Advisory Committee completed an application to went forward to the American Council on Historic Preservation. I could have messed that up a little bit, but they operate out of Washington, D.C. There are many federal agencies as part of this program, and last month Mayor Mattson received a letter from Michelle Obama that the city has been designated such a place. Staff certainly wants to recognize the assistance that our Historical Advisory Committee made in preparation for that document to be sent forward with council approval. And at this point, I believe, Director Rivas, that the council intends to have a ceremony on the September 10th to recognize the city's receiving that designation, and to provide perhaps some outreach to those involved, such as our Historical Advisory Committee members. And at this point, I don't think we have any items for the upcoming first meeting in September.
Okay. Any other matters from commissioners or staff? Okay, then I will adjourn this meeting tentatively to the next meeting in September 3rd, 2013. Thank you all. Oh, excuse me.
There's going to be a wonderful car show Thursday night downtown, so if anybody likes classic cars and street rods and hot rods and sports cars and all those things, come on down. It'll start about 6 o'clock and last for a couple hours.
Great, and we'll adjourn. Thank you.